the Honorable Congresswoman Geraldine Luistro.
Good morning, PJ.
Good morning po, Congressman.
If you are appointed as Ombudsman, would you still pursue government service upon expiration of your term? Because by then,
Yes po.
you haven't reached yet your compulsory retirement in the judiciary.
I will retire po and enjoy my life in Cebu.
In recent years, the legal community has been divided over the Department of Justice's issuances on preliminary investigations, particularly the adoption of the reasonable certainty of conviction standard as the basis for filing of cases in court. If appointed as Ombudsman, PJ, would you adopt a similar policy to ensure that only cases with sufficient evidence likely to result in conviction are filed? And for my last question, PJ, you have expressed views regarding the public disclosure of statements of assets, liabilities, and net worth. Do you believe that there are valid grounds to restrict access to these documents, given that they are being weaponized as well by political rivals?
Our next interviewer is the Honorable Congresswoman Geraldine Luistro.
Good afternoon, Commissioner Epres.
Good afternoon, Your Honor.
It's nice to see you again.
Yes, ma'am.
The last
Nice-
time was during the budget briefing.
Yes, Your Honor.
My first question is, you are the only applicant who has served extensively with the Office of the Ombudsman. First question, reason why you left? And second question, reason why you wish to come back, this time as head of the Office of the Ombudsman. I could sense, Commissioner Epres, that it is the honor which is attached to the Office of the Ombudsman, which is one of your considerations why you are envisioning to be one. And I wish to ask, that honor that is attached to the Office of the Ombudsman, is it not present as well in the Commission on Human Rights, you being one of the commissioners? To conclude this line of question, between becoming the chairperson of CHR and becoming the Ombudsman, which would you prefer? How do you appreciate the power of the Ombudsman to accommodate anonymous complaints? Don't you think that this is being used as a weapon by political rivals to go against these public officials? Thank you. It likewise appears from your profile that as Commissioner of CHR, you have attended to over 20 forums and seminars.
Yes, Your Honor. Yes, Your
I
Honor.
just wish to be enlightened how these forums and seminars broaden your understanding of the following. 1, accountability. 2, governance. And 3, protection of rights. Thank you for my last question. Of course, the right to public information is fundamental. Would you extend it to giving public access to SALN?
Our next interviewer is the Honorable Congresswoman Geraldine Luistro, ex-officio member representing the Legislative Department.
Good afternoon, Justice Gaerlan.
Good afternoon, Your Honor.
I wish to comment first your statement about your dream to becoming a watchdog of the erring public officials, and in line with that, your intention to launch Isumbong Mo Kay Sam. I think it brings the Ombudsman closer to the heart of the people.
Yes, Your Honor.
Hearing this program, Isumbong Mo Kay Sam. However, Justice, my attention was caught by one of your statements. You said a while ago, to regain the public trust in the Ombudsman. May I be enlightened? What do you think is the impression of the public today with regards to the Ombudsman? And what are your intentions or measures to introduce to be able to regain the same? For my next question, Justice, as a lawyer who was once in the litigation, it has been my appreciation that the highest honor indeed attaches to becoming a justice of the Supreme Court. I wish to ask, speaking about honor, if you are given the chance to choose between becoming the Chief Justice of the Supreme Court or becoming the next Ombudsman, which will you choose, Justice? Thank you, Justice. For my third question, one of the powers of the Congress is to conduct an inquiry in aid of legislation. And under the rules of the Ombudsman, the committee report can be considered a complaint. However, there has been a change with respect to their rules on how they will appreciate the committee report. In the 2022 rules, the same should be subjected to a fact-finding investigation first for a period of 60 days before they are docketed and considered as adversarial proceedings. But under the 2025 rules, once received, the same should be docketed and preliminary investigation shall proceed right away. Should you be appointed as the next Ombudsman, which rule will you adopt? Thank you. For my next question, Justice. In 2022, a law was enacted creating the Office of the Judiciary Marshal. Of course, this is to safeguard, protect members, officials, and personnel of the judiciary. Is it your position, should you be appointed, to adopt the same legislative measure with respect to the employees and officials of the Ombudsman? In terms of the amount of risk, Justice, that is attached to the judiciary vis-a-vis the risk that is attached to the office of the Ombudsman,
Yes, Your Honor.
which office do you think has more risk with respect to the officials and employees? So if the Congress will give you the prerogative to make the necessary proposal with respect to the proper response to the risk which is being faced by the people in the Ombudsman, would you take the position of requesting for the same Ombudsman Marshal,
Yeah,
similar to the context of Judiciary Marshal? Thank you. For my next question, Justice, the President has recently signed the Judicial Fiscal Autonomy Act. Again, if you will be given the chance to be the next Ombudsman, will you propose the same measure for the office of the Ombudsman? And how do you appreciate this in light of the principle of checks and balances among the three branches of the government?
Our next interviewer is the Honorable Congresswoman Geraldine Luistro, ex-officio member representing the Legislative Department.
Good afternoon, Commissioner Henares.
Good afternoon po.
I'm sorry I didn't hear very well how the case was concluded. Is it still pending?
No, after that, he again, every time there's a new commissioner, he would raise this issue. No? Then under the time of Commissioner Dulay, the Deputy Commissioner for Legal issued a second letter of authority. No? And I think that's the subject of the CTA.
How much were you able to collect, ma'am?
4 million.
4 million.
Yeah,
And the ombudsman case that he filed, is it still pending? Dismissed already,
yeah.
after 16 years.
No, it was dismissed while I was in office.
How many years did it take before the conclusion of the ombudsman case?
I think he filed it in 2013. It was resolved in a year's time.
Oh, fast enough.
Yeah.
For my question, Commissioner, earlier you mentioned about SALN,
Yeah.
that you are inclined to rely more on documents in SALN and talking about instead of testimonial evidence because witnesses can be harassed. That's what you said. About the SALN, this right to public information is of course fundamental But of course, we are aware as well that these SALN are being used as weapons among and between political rivals. So my question is, what is your position about this SALN, whether the same should be opened or not to the public? And for my next question, Commissioner, you mentioned about the testimonial evidence, quite frowned upon because witnesses might be subject to harassment.
Yes.
What is your position about our present witness protection mechanism? Of course, I acknowledge the vulnerability of witnesses, as you have mentioned. But if given a chance to become the next ombudsman, because testimonial evidence is as good as documentary evidence, what reforms or mechanisms perhaps can you introduce to make this witness protection more stringent, more dependable, and more reliable on the part of the prosecution process? For a separate line of question, Commissioner, kanina po you said, cases must be prepared thoroughly to avoid dismissal. That is before the Sandigan Bayan, no? Currently po, the committee reports of Congress in exercise of our power to conduct inquiry in aid of legislation are accepted by Ombudsman in the same nature as a complaint. However, there is this 2022 rules which says you have to conduct case build-up first for a period of 60 days, extendable to 30 days, before you can docket that, before you can consider that adversarial, and before you can proceed to preliminary investigation. This rule has been changed in 2025. Ang sabi po sa 2025, once the committee report is received, it will be docketed right away, and preliminary investigation shall proceed immediately. So if given the chance to be the next ombudsman, would you want to pass through the case build-up first or proceed to preliminary investigation? This will pertain to your appreciation of how the Congress is conducting their inquiry in aid of legislation. Thank you. And for the next question, Commissioner, of course, we were taught about the quantum of evidence required in preliminary investigation, that is probable cause.
Yes.
Because of this circular number 15 and number 28 of the DOJ, it was elevated to reasonable certainty of conviction standard. My question is, would you adopt the same standard if given the chance to become the next ombudsman in your prosecution process? Because I acknowledge that currently, the Ombudsman is adopting the probable cause standard. So is it your intention that to elevate it into reasonable certainty of conviction when you're given the chance to be the next ombudsman? I could sense your sharp sense about tax evasion. I wish to go back to the donation. If the same is executed between a parent and a child, or parent and children, what indicators do you have to say that this is fictitious donation? This is not donation. For my last question, it's been 10 years since you've been detached from the government. So I just want to hear, how do you intend to transition yourself now that you intend to go back? Good morning, Desla.
Good morning, Your Honor.
May we know the mandate of the office of DESLA? So basically, you have the legislative, the legal, and the DESLA proper.
Yes, Your Honor.
That is very enlightening.
Thank you, Your Honor.
How do you think is your experience as DESLA? How do you think the same will help and the same will be significant in your intentions about being the next ombudsman? In brief statement, DESLA, how do you draw the line between the jurisdiction of DESLA legal vis-a-vis the jurisdiction of the Ombudsman? Thank you. And for my second question, DESLA, RA 6770 grants the Ombudsman broad powers of investigation and prosecution. The question is it your opinion that the law is still sufficient for us to be able to combat graft and corrupt practices? You mentioned about the anti-corruption strategy.
Yes,
Can
Your
you
Honor.
please state in brief what is the distinct feature of this program which will help us address the mandate of Ombudsman? With your statement that we need the help of all agencies to address corruption, utilizing this proposed anti-corruption strategy, which agency do you think will be the lead agency towards that end? I understand that in your inclination to pursue the position of the Ombudsman, you've been thinking about this anti-corruption strategy. I wish to go back to my previous question.
Yes, Your Honor.
What distinct feature do you have in mind which is not being practiced still, you think will address really our problem on corruption? And in one of the statements made by the former ombudsman, he commented that corruption even exists in the office of the ombudsman.
No.
How do you think are we going to address that, considering that the office is supposed to be the lead agency in fighting this corruption? Thank you. For the next question, Desla. The office of the ombudsman is vested with contempt powers. That is to address the defiance of its lawful orders and directives. In your assessment, do you think this contempt power of the ombudsman is effectively implemented to address the defiance to its lawful order and directives? If there's already a standing temporary restraining order issued by the court and you are the ombudsman, will you still issue contempt order for the non-compliance of the supposed respondents? Next is about RA 3019. Do you think this is still sufficient law to be able to help the office of the ombudsman, again, address the anti-graft and corrupt practices? I came across a reading material which says that the ombudsman has the power to subpoena bank records. However, when I check on the requirements, one of those is court order. What is your position about this? Is it really the position of the ombudsman to push for the power to subpoena bank records? Because I think this is quite contradictory to the elements or requirements incorporated therein. Thank you. For my last question, ma'am. One of your proposed action plan is the readoption of the resident ombudsman,
Yes, Your Honor.
and you made mention about the integrity officer.
That's him. Yes, Your Honor.
Can you please enlighten us? How is this different from the previously practiced by the past ombudsman? Thank you, Desla.
Thank you, Your
And
Honor.
good luck. I hope you will realize your vision to become the next ombudsman.
Thank you.
Good morning, Justice.
Magandang umaga po, galang-galang na woman.
It is really an honor to be one of your interviewers. You used to be our RTC judge in Batangas.
Salamat po, salamat po.
Justice, for my first question, what does UNCAC stands for?
United Nations Conventions Against Corruption.
Earlier, you mentioned about having reviewed the anti-graft and corrupt laws
Yes,
of
ma'am.
other countries.
Opo,
Based
opo.
on your study of the same, ano pong nawawala dito sa ating existing law which perhaps make it challenging for the ombudsman to address the corruption in the country? Your therapeutic jurisprudence is
Yes.
very enlightening, Justice. For my second question, of course, AMLA should be considered as one among those laws which must be included in the codification. And in relation to the AMLA, if given the chance to be appointed as the next ombudsman,
Opo.
will you advocate for the power of the ombudsman to freeze the assets of erring and abusive public officials. Kanina po, Justice, you mentioned about the partnership with the COA. There are COA decisions, and I believe it is a practice to automatically transmit the same to the Ombudsman. Kaya lang apparently po, I think a significant number of which pending lang. I am not sure if they are subjected to fact-finding immediately or to preliminary investigation immediately by way of their motu proprio power vested in the Ombudsman. The question, Justice, is, would you advocate for the automatic preliminary investigation of the cases, subject matter of the decisions transmitted by COA to the Office of the Ombudsman? Justice, I understand that you spent most of your career in the judiciary.
Opo, opo.
To be particular with the Court of Appeals and the Supreme Court, where the administration of justice is by collegial body. So, if I may ask, Justice, how do you envision yourself administering justice as Ombudsman, which is the sole magistrate in the said office? Good afternoon, Attorney Matibag.
Afternoon, Your Honor.
You are advocating for the decentralization of the Ombudsman. You even pronounced or indicated in your documents the creation of additional regional offices. First question, is it your intention as well to put up provincial offices? Your intention that if there is an erring local official, instead of filing the complaint to the Ombudsman Central Office, we will be filing it in the provincial office of the Ombudsman. I wish to go first to the regional and the provincial office. If we adopt this system, Attorney Matibag, are you not apprehensive that the cases might be manipulated considering the network of influence of the local officials? I see. That is with respect to the portal and the online system of receiving the complaints, no? You call it real-time monitoring system. In addition to that, we used to have this resident ombudsman system which was adopted in the past in the Office of the Ombudsman. And I'm inclined to believe this is aligned with your decentralization intentions about the services of the Ombudsman. Proactive role in the investigation instead of simply reacting to the complaints. The questions are, is it your intention to institutionalize? Number one is the lifestyle check. Number two is the audit partnership. And number three is the motu proprio investigation. Yes, another thing is about the COA. Under the current practice, the COA is transmitting their decision to the Ombudsman. But that is really unclear whether this decision of the COA shall be considered or taken up for PI or for case build-up. If you will have the chance to lead this office, Attorney Matibag, how would you appreciate the weight as evidence of COA decision? Similar to that COA decision is the committee report of the Congress, and I am sure you witness your spouse taking part in various inquiries in aid of legislation. We likewise come up with a report based on the 2022 rules ng Ombudsman. The committee report of the Congress should be subjected to case build-up, but the rule has been changed in 2025. Under the 2025 rules, the committee report shall be automatically docketed and shall be subjected to an outright preliminary investigation. From a perspective of the possible next Ombudsman of the Philippines, would you want the committee report to go through the case build-up first, or you will appreciate that as significant for preliminary investigation already. For my last question, Attorney Matibag, of course, all the aspirants for this office are qualified. As a matter of fact, the task of the JBC is to select the best qualified. You are given the chance now to promote yourself. Anong meron ka na wala yung ibang aspirants? Good afternoon, Justice Musngi.
Good afternoon po, Madam Congressman.
Justice, the Justice Department issued 2 circulars, that is 15 and 28, technically elevating the amount of evidence that is necessary for preliminary investigation. To be specific, it is reasonable certainty of conviction standard, considering that one of the mandates of the Ombudsman is to conduct preliminary investigation as well. May we know your position whether or not you will be adopting the same amount of standard or you will be maintaining the probable cause amount of evidence. Thank you. For my second question, Justice, in 2022, the Ombudsman rule provides that the committee report from Congress shall be subjected to case build-up for a period of 60 days, extendable to additional 30 days. And during that time, it should not be considered as adversarial and should not be docketed yet. Now, in 2025, that rule has been changed, and it now provides that committee reports shall be docketed and scheduled for preliminary investigation right away. So, if given the chance, Justice, to be the next Ombudsman, would you adopt the 2022 rule or the 2025 rule? Similarly, Justice, the Commission on Audit, they transmit decisions to the Ombudsman.
Opo.
But it is really not clear what appreciation as evidence should be accorded by the Ombudsman to the findings of the Commission on Audit. Again, may we be enlightened on your position on how the decision of COA should be appreciated by the Ombudsman. Usually, Justice, but not all the time. It carries with it a recommendation for filing of violation of Anti-Graft and Corrupt Practices Act. So is this the same scenario that you are referring to with
From
respect
COA po?
to... Yes,
COA
Justice.
is
Thank you. And earlier, you made mention about the Ombudsman being a preventive arm rather than only an investigative and prosecutorial arm. I wish to ask your opinion about the possibility of giving power to the Ombudsman to subpoena bank records in light of the bank secrecy law and the recent jurisprudence on the power of the Ombudsman to look into this. Let's Justice, if you will be given the chance to propose a legislative measure on this, would you propose for granting of such power to the Ombudsman, the power to subpoena bank records? For my last question, Justice, I understand that the Sandigan is a collegial body. You act as one of the magistrates in a collegial body type of system.
Opo.
How do you envision yourself to becoming the next Ombudsman who will administer justice, you alone as the magistrate? Thank you, Justice, and good luck on your application.
Maraming salamat.
Our next interviewer is the Honorable Congresswoman Geraldine Luistro.
Good morning, Secretary.
Good morning, ma'am.
You've been a prominent political figure in Cavite, I believe for around 3 decades, as SB member, as governor, and ultimately as member of the House of Representatives representing your district. In 2022, you accepted the appointment as Secretary of Justice under the current administration. So, can you walk us through, Secretary, about your transition from being an elective official to appointive official? For my second question, in 2022, the 7th District of Cavite was left without a congressional representative due to your appointment, until, of course, Congressman Ping Remulla was elected in 2023. The question, Secretary, is, if appointed as Ombudsman, you would once again be leaving an office, this time the Department of Justice. So, what assurance can you give to the Filipino people that this time, as Ombudsman, you would see your mandate through and not relinquish it prematurely? So, does that mean that you will be finishing your tenure in the Ombudsman if given the chance to be appointed as such?
I hope so. I hope so. God willing, I'll be staying there. Yes.
For my next question, Secretary, of course, you are the proponent and the author of Circular number 15 and number 28. This is the rule which mandated for an increased amount of evidence from probable cause to reasonable certainty of conviction standard. The question, Secretary, is if appointed as Ombudsman, would you adopt the same standard of evidence in the prosecution in the office of the Ombudsman? For the next question, Secretary, under the 2022 rules of the Ombudsman, I'm sure you are aware of this, the committee reports from Congress should be subjected to case build-up, and the same should be considered non-adversarial and should not be docketed yet. However, that rule has been changed. In 2025, they provided for a rule that once received, the same should be docketed and subjected to preliminary investigation right away. If given the chance to be the next Ombudsman, which rule are you going to adopt? Similarly, Secretary, the Commission on Audit is transmitting their decision to the Ombudsman. But it is not clear as well under the rules of the Ombudsman whether the same should be treated for purposes of preliminary investigation right away or otherwise. What is your opinion with respect to the appreciation that the Ombudsman should be giving to the decision of the Commission on Audit? By case conference, Secretary, does that mean that you will be subjecting the same to a case build-up before the same can be considered for preliminary investigation? And given the very challenging task and mandate to the Office of the Ombudsman, I wish to ask, Secretary, would you advocate for a power to issue subpoena of bank records for Ombudsman? Nonetheless, Mr. Secretary, with all due respect, there is a Supreme Court decision which says that the same is still subject to the court order. So, in my interpretation, it went back to the original jurisprudence that it has to be a court order which will allow us to look into the bank records given the stringent requirement of the bank secrecy law. If you will be given the chance to propose a legislative measure, would you want that the Ombudsman be given the power to subpoena bank records without necessarily securing for a court order? That will be a stern warning for the erring public officials. And for my last question, Secretary, it is also tedious to secure a freeze order, which is being initiated by AMLA. I believe this is with the Court of Appeals. Would you advocate as well that the Ombudsman be given its own power to issue freeze order? Last question, Secretary. Of course, all the applicants are qualified. As a matter of fact, the JBC is tasked to select and nominate the best qualified to the position of the Ombudsman. ano pong meron kayo na wala ang ibang applicants? Thank you, Mr. Secretary, and good luck on your application.
Thank you, ma'am.
Thank you, Attorney. Good morning, Chairman.
Good morning po. Good morning po.
As former president of the Philippine Judges Association, you have expressed your opinion that abusive criticisms and unfounded accusations against judges can erode public trust in the judiciary. Question is, do you believe this principle equally applies to the Office of the Ombudsman, which also faces intense public criticism? The cases being handled by the judges or members of the judiciary are adversarial as well. So, what distinguishes the judiciary from the Office of the Ombudsman? Why, on your statement, judges should not be subjected to abusive criticisms and unfounded accusations, but with respect to the Ombudsman, you are now saying that they should not be on your skin. So it is because the respondents in the Ombudsman are politicians when the accused in the judiciary are not always politicians. Is that what you mean? For my second question, Chairman, if you are chosen as Ombudsman, would you be inclined to relax the existing restrictions on public access to statement of assets, liabilities, and net worth? Can you expound on the legitimate purpose that you asserted as the basis for making it accessible to the public? And with respect to bank records, Chairman, of course, the Ombudsman's charter has the power to issue subpoena bank records. However, in a decision of the Supreme Court, it says that the same should be subjected still to a court order. If you will be given the chance to propose a legislative measure on the power of the Ombudsman to subpoena bank records, would you advocate for this legislative measure? And may we know, based on your perspective as a former judge of the RTC, where should be the proper stage when the Ombudsman may exercise its power to subpoena bank records? So you are referring to that stage of preliminary investigation?
Yes, Your Honor.
How about with respect to the freeze order? Of course, the challenge of the Office of the Ombudsman is very tedious. And one of the challenges in the investigation is how to freeze the assets of the erring public officials. And if you will be given the chance to get this appointment, Chairman, and if you will be given the chance as well to propose a legislative measure, would you advocate that the Ombudsman be given its own power to issue freeze order? Thank you. For the next question, Chairman, the DOJ issued circular number 15 and number 28. This elevates the amount of evidence required for preliminary investigation from probable cause to reasonable certainty of conviction standard. The question, Chairman, is, would you advocate for the same increased amount of evidence considering that the Ombudsman likewise conduct? And then with respect to the committee reports coming from Congress, there is a 2022 Ombudsman rule which provides that the same has to be subjected to a case build-up that is for 60 days, extendable to another 30 days, and that the proceeding shall not be considered as adversarial, and that the case should not be docketed yet until after the case build-up. However, this rule, Chairman, has been changed in 2025 because the 2025 rules of the Ombudsman now provide Upon receipt of the committee report, the same shall be automatically docketed and calendared for preliminary investigation. In the past, Chairman, there is a practice to designate a resident ombudsman. This resident ombudsman in the past came from the government agency which is to be watched over. But there is a prevailing view that should this practice be adopted or re-adopted, that resident ombudsman has to come from the office of the ombudsman itself.
Well,
First question is, are you amenable to re-adopting the resident ombudsman system, which was implemented in the past? All right. And for my next question, the ombudsman has the power to issue contempt order. Would you be inclined to issue the same in case your dismissal order was issued a temporary restraining order by the court? In other words, you will not issue TRO. Baligtarin ko po, Chairman. Suppose you have an ongoing investigation or preliminary investigation against one erring public official, and then the court suddenly issued a temporary restraining order enjoining your investigation. In other words, you will heed to the TRO and you will stop the ongoing investigation in the ombudsman. Thank you. That is my last question, and good luck to you, Chairman Felix Reyes.
thank you, Your Honor.
Good afternoon, Judge Rodenas.
Good afternoon, Your Honor.
Your career reflects a mix of judicial, prosecutorial, and private sector experience.
Yes, Your Honor.
3 years as an MTC judge, served as a prosecutor, legal officer of private and public offices,
Yes,
as
Your Honor.
well as staff roles
Yes,
in
Your Honor.
trial courts and even in DOJ. Question, Judge, is how has this diverse background prepared you for the ombudsman responsibilities?
Well, Your Honor, with that diverse background, I can see that I am very much prepared in handling the office of the ombudsman. Why? Because I have been to private practice. I have been a litigation lawyer. I've also taught in the law school. I've become a prosecutor, and also as a judge. So, in that all sense, maybe I could address well the grievances of all people.
What experience of the various agencies you came from do you think you will utilize in curbing anti-graft and corrupt practices in the Philippines, in the office of the Ombudsman?
Yes, Your Honor, I think so, and very well so. Because in the private practice, you also litigate there, see to it that just has been done. In the prosecution, also, it's just a similar scenario in the Office of Ombudsman, where the Ombudsman also prosecute. Then I think by that alone, Your Honor, I could very well use my experiences being an ombudsman. And also, as a presiding judge, Your Honor, to see to it that not only the prosecuting the corrupt officials, so to speak, but also giving him the due process also. Because as we all know, even though the government official is accused of something, he is still innocent until proven guilty. He has also a right, much also the right of the Filipino people. As we all know, the rights of one ends when the right of other begins. So there should be a fair balance, Your Honor.
I understand the fair balance that you are pronouncing, but we have to consider, of course, that alike in your previous post and even in your current post, in the Ombudsman, you will be dealing with respondents who are government officials with the impression of having a network of influence.
Yes, Your Honor.
So how do you think will this be different from the previous post and the current post that you're handling right now? For my second question, Judge. Per records, a prior complaint was filed against you.
Yes, Your Honor.
That's by Judge Maria Teresa Lociano.
Yes, Your Honor.
This regards your act of improperly acquiring a copy of decision in a case involving a former client,
Yes, Your Honor.
which later you admitted and apologized for. Do you confirm that?
Yes, Your Honor.
How do you reflect on this incident today? And what lessons have you drawn from it about propriety and professional responsibility that will guide you if appointed as the next ombudsman? What I heard from you, Judge, is the justification
Yes, Your Honor.
for acquiring the copy of the decision complained of by Judge Maria Teresa Lociano. The question now is, what lesson did you get from that? Okay, and I understand, and of course you will acknowledge also a lot of laws on corruption were passed, no?
Yes, Your Honor.
We have this, the 3019, the
1379.
procurement law, which is 9184.
Yes, Your Honor.
Meron din tayong code of conduct and ethical standards for public officials and employees. We can also consider the AMLA law,
Yes, Your Honor.
no?
Yeah.
Kung tutusin, we have a number of
Yes,
laws
Your Honor.
already which address corruption in the country.
Yes, Your Honor.
If you will be given the chance to be appointed as the next ombudsman, would you advocate for their codification under one anti-graft and corrupt practices? Kanina, I've been hearing about the proactive
Yes, Your Honor.
vis-a-vis the reactive, no?
Yes, Your Honor.
With your inclination towards a proactive ombudsman, question is, although you have discussed this initially, would you institutionalize the power of the ombudsman for a lifestyle check? Okay, would you advocate for the power of the ombudsman to subpoena bank records? So is it your submission that when one submits a SALN, he is actually waiving his rights also against, with respect to the bank secrecy law? There is a a Supreme Court decision which says that despite the grant of power to ombudsman to subpoena bank records under RA 6770, the same must be subject still to a court order.
Yes, Your Honor.
So to go back to my
That
question,
should be my answer.
would you want the ombudsman to have its own power to subpoena bank records in a way that it will not be dependent anymore with the court? Well, with your answer, you're espousing for the grant of power to subpoena bank records as well as for the power to issue freeze order. The last question on that line of thought is, how do you balance that with the due process, right to due process of public officials facing cases in the ombudsman? There are three significant stages in the proceeding of the ombudsman. One is the case build-up, although the same is, I think, disregarded with the 2025 rules. Second is the preliminary investigation. And third is the trial. Which stage among these three stages of the proceedings do you think the ombudsman can exercise its power to subpoena bank records or can exercise its power to issue a freeze order? For my last question, Judge, under the existing rule of the ombudsman, they have the power to issue contempt order. Suppose you have a respondent who is already meted with preventive suspension, but the court issued a temporary restraining order on the preventive suspension order. Question: will you exercise your contempt order power to be able to implement the preventive suspension order? Thank you, Judge, and good luck on your application.
Thank you, Honorable Luistro.
Good afternoon, Judge.
Good afternoon,
Durgado.
Your Honor.
I heard a while ago about preventive and corrective justice. Can you please expound on corrective justice? Judge, you've mentioned about the Farmally controversy. In pursuit of your corrective justice, can you please identify to us what particular system which is existing needs to be revisited in order to realize the corrective justice that you pronounce? The system that you are referring to with regards to the Farmally is the procurement system that they utilized during that time.
Yes, Your Honor.
All right. Earlier, you likewise mentioned that the DNR exercised the regulatory power while the NRDC exercises the corporate power.
Yes, Your Honor.
May we be enlightened what specific engagements or projects have you launched in line with the mandate of NRDC diversity? How do you think this very distinct experience of yours will be able to contribute in addressing the mandate this time of the Ombudsman? Judge, it appears from the records, this is my second question. In 2010, the Supreme Court reprimanded you for undue delay
Yes, Your Honor.
in deciding a case which was submitted for resolution but decided only after 15 months instead of 90-day reglementary period. May we know what lessons did you learn from this incident? Now, for
Thank you,
the
Your
third
Honor.
question in the written output that you submitted, you described the Ombudsman as a tribune of the people, not only protecting citizens from abuses of power, but also capacitating them to claim their rights and demand accountability. Can you please expound on this? You mentioned that by tribune of the people, you would like to bring them in the table of the government, educate the people on how they're going to claim their rights. That is really very idealistic, Judge.
Yes, I know
But
that,
the
Your Honor.
question is, what programs and reforms are you going to introduce to the existing system of the Ombudsman for us to realize that the envisioned tribune of the people?
Corruption.
But of course, while the complainant are entitled to due process, the public officials are entitled as well. So how do you think will you protect the right of the public officials whose SALN will be publicized in order that this will not be used as a weapon against them by their political rivals? If you will be given the chance to propose a legislative measure in your capacity as, let us say, the future ombudsman, would you initiate one that grants the ombudsman? Next question, Judge. We have witnessed a lot of incidents when star witnesses are recanting their own testimony. How do you think are you going to address the present witness protection mechanism system in order to avoid recantation of testimony? There is an ombudsman rule that is 2022 which says that the committee reports of Congress should be subjected to case build-up for 60 days, extendable to another 30 days. And that the same should not be considered as an adversarial proceeding and should not be docketed yet. However, Judge, that rule has been changed in 2025 because under the 2025 rules, once received, the committee report shall be immediately docketed and the same shall be calendared for PI, preliminary investigation, immediately. So if given the chance to be the next ombudsman, may we know which rule will you adopt? That is my last question, Judge. Thank you and good luck on your application.
Thank you, Your Honor. Thank you so much.